Good morning, Mr. Clement.
Good morning, Francesca.
Thank you for taking part at this series of interviews focusing on emission reductions rights in the context of jurisdictional REDD+. Before we actually start with the interview, could you please introduce yourself?
So my name is Clement Akapame. I'm a Ghanaian lawyer. I work with a law firm called TaylorCrabbe. We're in partnership with the UK law firm Clement Akapame, where we work closely within the forest sector, particularly on forest legislation and how you can use the law to ensure effective enforcement of forest rights, to ensure effective resource regulation and also effective sharing of benefits that are derived from these resources. I also teach at the Faculty of Law of the Ghana Institute of Management and Public Administration. So that's what I do.
Thank you very much. Mr. Clement, as you well know, countries like Ghana currently are accessing different sources of climate finance related with REDD+, either through results-based payments or voluntary carbon markets, need to ensure a certain level of clarity as it concerns emission reductions rights, including their capacities to transfer those rights and allocate REDD+ benefits. Can you please tell us how Ghana is progressing in order to clarify emission reductions rights, and what has been or is your contribution in the lawmaking process in the country?
Thank you. So I think that as a lawyer, the starting point will be that there's no legislation currently in place directly in Ghana dealing with carbon emission rights, meaning that the ownership right or exploitation rights cannot be stated with a certain level of certainty. Now, for us lawyers, ownership and exploitation rights are very important, because if there's clarity around those indices, then we are able to know who is able to transfer and who is able to get those benefits. So because of the absence of legislation, steps are being taken by government to try and develop a certain legislative framework that will give clarity to carbon rights and how they are treated. So currently in place in Ghana, there's only one functional emission reduction program. That is the Ghana Cocoa Forest REDD+ program. And it's a program that relies on contractual arrangements between stakeholders to clarify emission reduction rights. So as opposed to having legislation that clarifies and sets the framework, in the absence of legislation, the Forestry Commission, the Ministry of Lands and Natural Resources are using programs like the Ghana Cocoa Forest REDD+ program as an entry point to enter into contractual arrangement with stakeholders to clarify emission reduction rights. So in this arrangement, it appears that the government is viewing emission reduction rights more as an ecosystem service of storage as opposed to a natural resource. So, so issues around naturally occurring trees, planted trees, and the underlying land tenure system becomes questions that need to be clarified. So in summary, there's progress being made using programs in the absence of legislation to clarify how emission reduction rights or emission rights are assigned, are held, are transferred, and then benefits received for these emission reduction rights. And there are a number of stakeholders that are involved in this process, including landowners, traditional authorities, community members, and even to a very large extent, state actors as well, involved in this framework to try and use a program in the absence of legislation to clarify emission reduction rights. Yeah.
Thank you, Mr. Clement. Can you also tell us, but that's part of this very first question, something more about the role of the CREMAs?
Good. So I mentioned that this program thrives on entering into contractual arrangements with communities. So this program revolves around what we call the Community Resource Management Area System, where communities come together to undertake certain activities, and these activities must be first sanctioned under the program, and then these CREMAs now work together to transfer their rights to what we call the HIAs, the hotspot intervention areas, and then these hotspot intervention areas also move up and form what we call the hotspot intervention area management boards. So there is a certain structure where communities transfer their rights through these structures. And at the top of the hierarchy, the HIA is now able to transfer on behalf of these communities these rights to government, and then government subsequently trades it. Now, the little issue with and that's a legalese issue, is the status of these CREMAs. Now, when it comes to property rights, it is the owner of the property who is able to transfer. That is basic law on property rights. So these CREMAs, they are communities, so they have collective ownership. Now, the CREMA doesn't have a legal capacity or legal, it's not a legal entity. So this is being solved through the wildlife bill, which is currently before Parliament, where the CREMAs will be given a certain recognition in law. Now, that recognition in law will now give them capacity to contract. And in that capacity to contract, they will now be able to transfer those collective rights. Now, if we don't solve that issue of the capacity to transfer, then when they transfer, people will question whether or not they have even rights to transfer in the first place. So the CREMAs are at the heart of the Ghana Cocoa REDD Plus program, and it uses communities who will engage in activities sanctioned by the Forestry Commission in collaboration with the Cocoa Board to ensure that they are able to take part in the program. So the CREMAs are at the base of the program in Ghana.
Thank you very much for the very comprehensive answer. Based on your experience, what do you consider are the main challenges Ghana is facing in order to comply with emission reductions legal requirements under different programs and standards, such as the FCPF carbon fund or RBPs?
Yeah, so I think one of the major challenges will be the question of clarifying who owns and who can transfer carbon rights. I think that's one of the major challenges. And because of what I said initially about the lack of legislation and the fact that the current structure we are using with the communities and these contractual arrangements around the ER programs, there is a certain missing link on legal capacity. So that happens to be the major challenge. So once this challenge of clarifying who owns and who can transfer is put in place, I think that it will be very easy for countries like Ghana to sign up onto these voluntary, like the carbon fund and the RBPs, because if you look at the requirements for signing up onto these things, clarity on ownership and transfer right is key. So once you cross that hurdle, it will be very easy to do that. And once we are trying to do that through legislation in the moment using the wildlife bill. So immediately that is done, we should be able to do that. But I must say that the current arrangement of using the benefit sharing scheme and the CREMA system provides an entry point. But what needs to be clarified for the purposes of signing up onto these standards, such as the arteries and the carbon fund, will be to ensure that there is clarity, even in the absence of legislation. And this clarity does not go against fundamental principles of law, like ownership of property, like tree tenure, and stuff like that. Yes.
Do you consider as a challenge the current secting of the land tenure system in Ghana, or on the contrary, an opportunity for clarifying the price?
So I think that the land tenure system currently in the country and the tree tenure arrangements we have currently in the country is very complex. So if it is not planted trees, which is very clear as to the one who plants, owns, and everything, all other trees that are naturally occurring are vested, wherever they are found, are vested in the president on behalf of the schools concerned. So this vesting arrangement also creates an issue where you have trees on farms, where there are farmers who are nurturing and tending these trees. So this has been seen as a challenge. And in the last couple of weeks, there's been pronouncement from the ministry where steps are being taken to vest trees on farms in farmers, so that now the farmers will have, to an extent, some management rights, or quote or unquote ownership rights. But the ownership rights will be limited ownership rights, because it will not be ownership rights that will allow them to alienate or sell the trees. But ownership rights that comes with management rights, ownership rights that gives them a right to share in the benefits when the trees are taken, ownership right that gives them the right to tend or nurture the trees and ensure that they attain the structure that they require. So the complex nature of our land and tree tenure arrangement is also being clarified, because there are instances where even with planted trees, the one who plants the tree is different from the one who owns the land. So now the question becomes, will the benefits deriving from the planted trees be shared only at the level of the one who planted, or the landowner also has a role to play? And these are all being clarified, where we have proposed, for instance, that if it comes to planted trees, the state should not intervene on who gets what. It should be the one who planted the tree. Whether the landowner gets or not should be an arrangement between the planter and the landowner. And then that can be a contractual issue, and that does not need to even have legislation to explain that. So yes, that's one of the progress being made at this point. Yeah.
Thank you. And what do you consider then the preferable options for Ghana, in order to find viable solutions to these challenges and guarantee a rights-based approach?
I think that from a very legalese point of view, Ghana should, as soon as possible, have a legislation that clarifies ER rights. Now, this legislation should state that carbon rights are vested on a similar arrangement as already existing, but then devolve management rights or exploitation to the CREMAs and HIs. So I am advocating for a legislation that clarifies carbon rights, and that the state vests the carbon rights in itself, but then when it comes to management and exploitation rights, that can be devolved to the CREMAs and the HIs, as it has been done in other areas like in wildlife. So all wildlife resources are vested, but then when it comes to the exploitation and management, there is some devolution that is done for the creamers. So this will allow the creamer to sustainably manage the carbon, finance activities that supports this management, and then receive financial benefits for it. So that's, for me, the first preferable option. This will also have to be accompanied by some reform in land and tree tenure, as we have discussed, to bring clarity and try and align the issue of naturally occurring trees with land ownership and giving landowners rights over naturally occurring trees within their scope. Now, if this clarity is brought, reform in land tenure and then legislation on ER rights, I think that we would have, we'll make a lot of progress, yes.
Thank you very much, Mr. Clement. And in order to conclude, would you like to share any lessons learned that could apply to other countries in the region?
So I think that the major lesson that we have learned, trying to study this area, is the fact that this whole idea of carbon rights appear to be new, and there is no legislation in place supporting it. And countries are trying to use existing laws, which laws were first put in place to regulate the trade of timber, which laws actually are counter to what you're trying to achieve with emission reduction rights. So the first lesson I've learned is that countries, in the absence of legislation, can take programs as entry points to test available options of how to deal with the issue of ER rights, and then as time goes on, provide legislative clarity. Because when it gets to the point of the trade, if you don't have clarity on what you're trading, as in relation to who owns and who can transfer, you are unable to trade. Nobody will trade with you if there's lack of clarity. So that's the first lesson that I have learned. The second lesson that I think that other countries should also pick up is the issue of trying to do this intervention of REDD+, this clarity, not as a sector-specific program, but a holistic program that brings in other sectors and other components, including non-state actors. Because if you have a multi-stakeholder process around these programs, there is a lot of ownership and there's a lot of sustainability of these programs. And then that will give you the foundation to translate these programs into viable policies, strategies, and then in the long run, in legal texts. So these are the two lessons that I've learned that I think I can share.
Thank you very much, Mr. Clement, for your very enriching thoughts and considerations focusing on this subject area. As we know, some of the aspects, specifically those that relate with tenure rights, are sometimes quite sensitive, but I think Ghana is proceeding in the very right direction, as it is, very much centered in giving a strong focus on the existing community management groups and their roles in managing sustainably forest lands and eventually in transferring rights on the existing or maybe new arrangements that will be adopted for that purpose. So I will conclude here, but I hope that you will also intervene in our online discussion in the context of the D group on REDD+ and forest governance. And once again, all the best and have a safe day. Thank you.
Thank you very much for this opportunity, and we will continue to interact to ensure that we create clarity particularly using law around this issue of emission rights reduction. Thank you very much.